But thank you all for joining us. I'm Ben Winters. I'm the Equal Justice Works Fellow here at EPIC, and I'm going to be moderating today's discussion. I'm really excited to be joined by these three academic experts and practitioners to talk about risk assessments, what they are, how they can be dangerous, and how people are and can be responding. Our first panelist is Sean Hill. He's a visiting assistant professor at Ohio State University, Moritz College of Law. He has a forthcoming law review piece about risk assessment tools, examining bail reform and algorithmic risk assessment tools through a critical race lens. It's called Bail Reform and the False Racial Promise of Algorithmic Risk Assessment. It'll be published in volume 68 of the UCLA Law Review and will be available on Sean's SSRN in the next few weeks. You can find him on Twitter at SeanESQ. Our next panelist is Vincent Sutherland. Vincent is the executive director at the NYU Law Center for Race, Inequality, and the Law, as well as an adjunct professor at the school. Vincent also has a law review article coming out later this year on algorithmic tools and critical race theory, and was a public defender prior to his position at NYU. You can find him on Twitter at VMSutherland. And last but not least, Megan Stevenson is an associate professor at University of Virginia School of Law. Among her many publications is great foundational work about algorithmic risk assessment tools and their shortcomings, especially issues of transparency, age, and what happens when results of these tools are placed in the hands of very human judges. You can find her at Megan T. Stevenson on Twitter. So today we're talking about risk assessment tools, and I promise I'll give my panelists most of the talking, because they're much more interesting than I am. But on a basic level, for some context, a developer decides on a set of factors that are collected and inputted into a system that calculates a risk score for a defendant or incarcerated person. The factors are different for every tool, but include current offenses, past failure to appear at trial. It also includes some age, racial, personal, medical, social, and geographical factors about a person that can become proxies for race or are subjective. At the pretrial level, at least, which is what we'll be focusing on today, the results of these tools are used to estimate risk that an individual will commit an offense again, as well as the supposed likelihood that that individual will not show up at their trial. So then these scores are either a number or some sort of designation like low, medium, or high risk, which are then given to judges to help them decide on bail, detention, and sentencing. The tools are sold as more objective, more cost-effective in the long run, and a key component of bail reform. But although the tools vary, it's been found through research of people like our panelists and so many more that there are disproportionate negative impacts of these tools based on communities that are already sort of impacted negatively by the criminal justice system. We're going to get started exploring these topics and how we can move forward with the panelists. But I want to say that Black Lives Matter, and acknowledge that we know Black, Brown, and Indigenous communities are targets of more surveillance and harsher policing than others, and risk assessment tools are inextricable from historical arrest and enforcement patterns. Lastly, there is a Q&A sort of button on the bottom of your Zoom screen. So if any of our attendees have any questions for our panelists throughout, just ask that and we will get to it and set aside some time at the end of the panel. So firstly, starting off with Megan, do you think you can go into a little bit more detail of sort of the life cycle of a risk assessment tool, like how the input data is collected, and then how a judge might get it and use them?
Well, it depends on the tool you're talking about, because things have changed over time. In the earlier days of kind of pseudo risk assessment tools, there were just a group of people that were familiar with the criminal justice system. Some of them were criminologists, some of them were psychologists, and they said, well, we think this thing is predictive and that thing should be predictive. Let's add 4 points for having this characteristic and 2 points for having that characteristic. Over time, they've become, moderately more sophisticated. I will say they are not incredibly sophisticated tools from a statistical point of view, I think the classic way that they're developed now is that somebody gets a data set of, let's just say we're talking about a pretrial risk assessment tool. Some organization gets this data set of prior people that have been arrested at the pretrial stage. Some of them get released, some of them are detained. Some of the people that are released get rearrested within some period of time, say a month or 6 months or whatever. And they do statistical analysis on this data set to identify what factors predict the likelihood of reoffending. And then, to be perfectly frank, they then kind of massage it a little bit and be like, well, I think it should look a little more this way. It's really not, they're not fancy, not fancy tools, a lot of human discretion, a lot of messiness going into them. And not to mention, even if it was built, even if one were inclined to build it in the most kind of rigorous top-notch, statistical, like top-shelf statistical instruments, you're faced with very fundamental problems with these risk assessment tools, which is that the data is not what you want it to be. I mean, to begin with, you only see data on people that are released. So the first thing you do when you build this risk assessment tool is you drop everybody that wasn't released. And an essential assumption of this is that people that are released are similar in some ways, or similar enough to the type of people that are detained that the risk assessment applies equally well to everyone, not just the type of person that was in your original training data set. And then of course, as has been well noted by many different people, both the input variables, things like the number of prior arrests, the neighborhood that you live in some cases, so on and so forth, criminal history, as well as the target variable, the thing that the tool is trying to predict, which is, usually something like rearrest or reconviction, they're not what we want them to be, which is actual criminal activity. They're a proxy for criminal activity that is filtered through, our highly, racially disparate criminal justice system.
Right, thanks, Megan. And Vincent, I know you've spoken a little bit about kind of going off what Megan just said about how the field of inputs fail to take into account for other actors in the criminal justice system and kind of act as the individuals they're considering for bail or release or detention are acting completely within themselves and not as part of a larger system that kind of impacts those. So if you could speak a little bit more to that, that'd be great.
Right. So I think Megan's exactly right. And I think, the fundamental point for me when I think about the use of these tools, and I think for many others, is that the reality is that we live in a world that's awash in racism and inequality. And I think every single data point that we think about that these tools are going to rely upon are going to be affected by that reality. And therefore, it's often the case that what we see are tools that are producing back or mirroring the inequities and the racism we see in the world we live in. The data itself is affected with racism based on kind of what Megan mentioned, just kind of racist patterns of belief, for example. So you think about, if you imagine we're thinking about arrest data or rearrest data or charging data as a point of entry in terms of what we're going to use to predict someone's behavior, forecast someone's behavior, all those things are going to vary based on policing patterns in a particular neighborhood or community. And so if you have a place like New York City, where you're seeing 9 out of 10 people being stopped, and the overwhelming majority of them being Black or Latinx, and having no criminal activity founded on them, but they have some arrests or some other interaction with law enforcement that's racially tainted, that taint is going to carry through to the algorithmic tool and then reflect back those same biases and the predictions that it's making about who's going to be successful, who's not going to be successful. And so I think, part of the challenge is understanding that racial bias kind of taints our world, and therefore it's going to taint the data that these tools are relying upon to make their forecasts and predictions.
And thanks, Vincent. Sean, can you explain how these tools are sort of deployed with limited skepticism because how they often accompany greater bail reform efforts? And if the data we've seen so far that the deployment of these tools actually align with the goals of the bail reform movement?
Yeah, great. So one, thank you so much for having me today. And I've been engaged in a good deal of analysis around how exactly are these instruments interacting with the broader demand for bail reform, and particularly the demand that's coming from grassroots groups and grassroots coalitions. We've obviously witnessed bail reform, not just in New York, but in California and New Jersey has received a tremendous amount of attention in recent years as well, with New Jersey and California standing out because of this deep reliance on pretrial risk assessment instruments. I think the concerning element beyond popular understandings of technology, where we are immersed in new technology. This obviously influences our perception of it. I think that we have movies, films like Minority Report, so when we kind of account for popular culture, the idea is that yes, technology is naturally going to move us towards more equitable outcomes, and in the bail context, more racially equitable outcomes. And so I really contest that in my writing, in my scholarship, in terms of really identifying what is the nature of the demand that's being made on the ground, right? And we have a series of public-facing letters that coalitions have issued, both in California and New York in particular. And the demand is not merely to eliminate cash bail, right? Cash bail is conceived as a means to an end. And the end, the objective is dramatic reductions in our pretrial detention rates, but beyond that, not relying on our criminal legal system to respond to a variety of social ills and social problems, right? So it's a problem of how we conceive public safety. And we're seeing that obviously in the vein of the movements we're witnessing right now, but those movements have also been equally engaged in the bail context. And so the demand from those groups, again, is not just to eliminate monetary bail or to improve risk assessment, but rather to pursue a strategy of bail reform that is going to lead to these dramatic reductions in pretrial detention. And so when we kind of seek to assess these instruments in relationship to these underlying demands, it becomes evident that they're not actually responsive to the demands of grassroots groups. They're more responsive to how traditional stakeholders have conceived the problem of bail. The popular discourse is that the problem is one of wealth, monetary bail, right? Wealth disparities, and judges not being able to accurately predict risk. And so that lends itself to the adoption of pretrial risk assessment instruments, but that is not the framing of grassroots groups. And so my concerns ultimately lie in a long-standing history of our legal system being utilized to neutralize the demands of grassroots groups, particularly directly impacted people. And my concern lies in us really witnessing this phenomenon unfold yet again with the charge bearer in many ways being proponents of risk assessment instruments.
Great, thanks. Kind of working off some of these preliminary concerns that we've discussed, there are a number of developers that make these tools. Some of them are private, some of them are public, and there's two major proponents of these tools over the last few years have been the public safety assessment, which was done by Arnold Ventures, as well as the Pretrial Justice Institute, which have been sort of kind of advocating for pretrial risk assessments and their adoption in order to kind of help this movement go along and improve the bail system, but actually following a number of research and skepticism over the last few years, only this winter, they have both sort of qualified their statements that pretrial risk assessments are not this sort of fix-all that they were at once billed to be. And so the Pretrial Justice Institute has sort of brought back their stance considerably, and the public safety assessment has said that there are, their tool should not be used by itself. They have to consider other things. So I'd love if, Megan, I know if I want to talk a little bit about some of this research that has led to sort of this pushback. And Megan, you had a paper about what you call the double-sided sort of youth, and how that sort of disadvantages younger people when using risk assessments. And so if you could talk a little bit to that, that'd be great.
Yeah, so this is like something that I started thinking about when doing work on actually what led me to this is I did a reverse engineering of one of the most commonly used proprietary risk assessment tools called the Compass, which is totally black box. It's a for-profit company that built and developed this. They won't tell us anything about what's what the formula is. They tell us a little bit about what goes into it, but they don't say how it's weighted and so on and so forth. And this tool has been very controversial. And I realized you could do a kind of partial reverse engineer to figure out what's in there and what the different weights are. And one of the interesting things that I discovered when doing this is that almost 2/3 of the variation of Compass's risk of violent recidivism tool comes entirely from age. It's actually hard to predict violent recidivism in particular because it's fairly uncommon. And so, tools like this put just an enormous amount of weight on age. And statistically, that might not be unfounded. Young people are at a much higher risk of committing crime and violent crime than people in older years. It's like one of the most, it's criminology 101, one of the most kind of robust relationships that we know about. But what that raises is this kind of tension, which we call a double-edged sword, where on the one hand, understandably, to the extent, the rationale of risk assessment is lowering crime by, preventing those at highest risk of committing crime, from being able to commit it. But on the other hand, they're teenagers and young adults. And, there's a long tradition in our criminal justice system of using using youth as a mitigator instead of an aggravator in sentencing. And pretty much, it's not just Compass. I mean, Compass is a particularly, egregious example of this, but all risk assessment tools, like, I keep trying to, drill this on, like, they're not fancy. These are simple tools. And a lot of the weight and the predictive power actually comes from age. And, what you wind up having is young, particularly young men, being called high risk of violent recidivism, which is a very stigmatic label. That's a very, if you get that label, like, somebody notices. But really, it's just that they're 19 and they've had a few run-ins with the law before. Like, maybe they've got a couple marijuana arrests on their criminal history. So that that's what that paper is about. Just how this tension and how risk assessments in when they're not transparent or when they're hard to interpret, they can result in this stigmatic condemnation of young people solely, for something that they can't help, which is their youthfulness.
Right, thanks. And either Vincent or Sean, if you want to talk a little bit more onto that issue of the stigma that's put based on youth, that stigma through the risk assessment use is also sort of put on, young Black men in particular, but for a variety of people who live in either more higher crime communities, which also sort of is oxymoron and hard to pin down because higher crime communities also sort of are over-policed communities, and they don't take into account the fact that offense data is really arrest data rather than everyone doing those offenses in general. So if you could talk a little bit more about how beyond just straight up the factor of race goes into other factors that are commonly used in risk assessments that become basically proxies for race, that disadvantage and stigmatize, Black, Brown, Indigenous communities even further, and basically kind of start them off at a disadvantage.
Sure. So I think part of the real challenge in thinking about that question is kind of a lot of the factors that risk assessments might use all correlate with or are driven by racial inequality. So if you think about employment status, housing status, stability of your neighborhood or stability of where you might live, kind of other factors, all these things kind of fall along racial lines and have been demonstrated time and time again to be influenced and shaped by one's racial identity. And therefore, when you have a tool that can rely on those factors that are all shaped by one's kind of experience based on their race and identity, that's going to reflect back those same biases in the forecast that these tools produce. And so I think the real challenge when you think about risk assessments and these types of instruments is that they often treat race as a bug in the system, so to speak, rather than a feature of American life. And I think if we think about it as kind of like a feature level problem rather than a bug level problem, something we can erase or get rid of, but instead have to confront and address and account for if there are ways you can account for it. I don't even know that there are ways you can account for all the ways in which race might shape someone's life. I think you start to begin to move down the path of a different set of answers when you think about the way in which these tools are used, in the way in which they're constructed.
Right. Yeah, and I would just add, right, I think that this is why it's also important to really account for history surrounding race, as well as history surrounding the origins of our criminal legal system when we talk about pretrial risk assessment instruments, right? They're emerging within a much broader entrenched apparatus. And in this country in particular, it's not near as much of a global phenomenon, but if we were to explicitly look at the United States, right, perceptions of Black people as exceptionally dangerous have justified a series of discriminatory policies in this country. This underlies right, the institution of slavery. It also justified Jim Crow laws. And obviously, more recently in the latter part of the 20th century, the presumption of Black criminality really drove the turn towards a series of mass incarceration policies. So I think it's important when we talk about these instruments, it isn't merely a matter of the factors that they account for, but it's also how they lend greater legitimacy to dominant, if unstated, presumptions. And particularly that our criminal legal system, the reason that we witness the overrepresentation of Black and Brown people in our criminal legal system is because they are, in fact, exceptionally dangerous. They are, in fact, a danger to the public, and right, that this is integral to public safety. And so I think these instruments not only encourage greater investments in the carceral system, but they really move us away from this deeper interrogation we need to engage in around how our criminal legal system has actually done a tremendously poor job of keeping all communities safe. That safety has been confined to very select communities, and that routinely those who lie at the intersections of multiple marginalized identities frequently cannot find safety within the criminal legal system or as a result of any of its agents.
Yeah, and I just wanted to just add to that really quickly. I think one of the things that always struck me, even as a public defender, and kind of, these tools were in operation and use when I was practicing. And they always operated kind of in the background, humming along, and they weren't really challenged or questioned in very rigorous or serious ways. And I think over time, folks have there's this kind of growing recognition about the inequity in the system itself, in the criminal legal system. But I think there's also, along with that, this presumption or assumption that if we just kind of tweak the dial a little bit, or we're able to just pick the right people, or just change this one little factor this way or that way, that we'll actually be able to fix the system. But my contention is that the system is actually not broken. It's actually working the way it was intended and the way it was designed. Kind of all the ideologies and all the kind of concerns that Sean just raised about the way in which race operates and the way in which our criminal legal system operates are basically as such because the criminal legal system helped to define the way in which race was valued or undervalued or devalued, and helped to delineate and demarcate those lines between who was free and who was enslaved, who was able to go to ride a bus and who was not, who was able to kind of live under the laws of Jim Crow and who was not. And so we have a criminal legal system that actually always been operated under the guise of kind of social control and marginalization of people of color, particularly Black and Brown people in this country. And therefore, when you have tools that are just saying, let's make the system just a little bit more efficient and work a little bit better, you're not actually kind of upending the root problems with that system. You're just kind of perpetuating it in many ways. And so I think that's a real concern when I look at the way in which these tools operate. And I think when I look at the way in which people were kind of designing and building these tools for use, sometimes lack that historical context and that historical framework and that understanding of the way in which our criminal justice system operates. It's not broken. It's operating as it was designed and as it was intended, and it still does so today.
Right. I guess follow up on that. Do you think that, and thank you for all those words, Sean and Vincent, both. Do you think that saying off of that, I know it's kind of not fully embracing the point you've made that that pretrial risk assessments are maybe not something that can operate in an equitable manner given the historical context. But do you think that there are things that risk assessment instruments and developers of those could ideally do in order to account for some of these facts? Is transparency as big of a step as it's given credit for? Which is kind of a hard thing because transparency is fought for because it's not there, but at the same time, it's more than transparency than we're fighting for because we know that there's going to be underlying issues. So I guess the question to Vincent, Sean, or Megan is how do you think some of these deficiencies can be accounted for in a world where risk assessments would be used?
I'll jump in and say that I don't think they can be. I don't think, people talk about making a race neutral risk assessment or debiasing the data, and I just don't think there's a feasible way that can really be done, and or if like, and that attempts would run into serious legal challenge, at least in our current world. I don't, who knows what it'll look like in the near future. I mean, I think that like, like I think more for me, it's always been about more than the tool, but how the tool is used. And if the tool, so like here is why I think certain people were on, like the Pretrial Justice Institute were on board with risk assessment for a while. They viewed it as a way to get a reform passed, and now like there's more momentum for reform. It's certainly not necessary, but like at a certain point you were like, you had to sell this thing to a bunch of skeptics. And the way it was sold was like, you're going to adopt this tool. It's very smart on crime, very scientific, very validated. And we're going to be able to have our cake and eat it too. And like somehow, because people are excited about this like shiny new risk assessment tool, we're going to be able to pass something that, resulted in a real decline in the, in the incarcerated population. And, if you read the language of some of the statutes that got passed in like the first wave of bail reform, like a part of me is like, yeah, this sounds great. It's a presumption of release for all low and moderate risk people. That's like 90% of people, like fantastic. But, they didn't have any, they weren't binding. They didn't have any teeth. They're like presumption of release, but here, judge, you can keep going, you have the final say, which is another way that this thing got passed, because you weren't really shifting any real power. You weren't really doing anything that had any, that was like really binding on people. And, a lot of what happened was like not that much change. And so then there was this sort of like second wave of people coming along, and looking at risk assessment, from a much more critical lens, and also saying like, it didn't do what you guys promised it would do. Like you don't just adopt a risk assessment and see a dramatic reduction in the incarcerated population, and plus there's all this problems with the data, and plus it like, like aligns with this, very, like racist kind of fundamental idea of the criminal justice system, of like the criminality of Black people, and like it's, like there's a lot of reasons to be displeased with this, but the, like, if there was a way to use them, in the best way possible. For me, it's not about like debiasing the data or tweaking the tool. It's about implementing it in some way that led to an automatic decision rule that really led to like, for 90% plus of the people that are arrested, like just go home, like, or don't even arrest them. Like, don't even bother, just like go home, go home. There's no reason to book you into jail. There's no reason to hold you overnight. There's no reason to bring you in front of a judge. Right. We have a presumption of liberty here, and if there are some instances where somebody poses a very clear, specific, specifiable, immediate serious danger or immediate serious risk of flight, like bring those people in and like try and figure out how to deal with them. But like, that's not how they're adopted. That's not how they're used. And they're not even necessary for those purposes. So.
Yeah, I mean, to me, I think Megan's exactly right. And I can speak to kind of the experience I had in New York. I sat on a research advisory committee that was tasked with helping to provide guidance and consultation on their redesign of a release assessment instrument that they're using there now. And part of the piece that at least convinced me or helped me become comfortable with actually engaging in that process was, number one, just seeing kind of how the sausage is made, and seeing it from kind of an inside perspective, which I think is pretty rare as someone who is not a researcher. But I think also number two is trying to figure out, are there ways that we can set the points of release so high that the tool is suggesting that the overwhelming majority, 90 or 95% of people, should be released outright with no conditions or no kind of further interventions from the criminal legal system. And then for that very, very small percentage of people that may require further kind of scrutiny, is there a way you can impose some type of an actual hearing with evidence, with discovery, a more rigorous process to determine what are the needs that those people, individuals have to have met in order to ensure they're going to be able to return to court in a timely fashion. But I feel like I don't feel like there is a way to kind of scrub the data of the race, of racism or racial bias. And even in the context of which I'm talking about, we're still thinking about kind of how these tools can operate within a system that we all agree or have some sense of being illegitimate or problematic in some way. And so I think
right.
the challenge for us is to think through, like, what type of system do we actually want to have in place and build, and then build tools that reflect or respond to that system rather than kind of building tools that are going to tinker around the edges. I think Megan's also right in terms of the way in which these tools are used makes all the difference, and kind of the political nature of pretrial decision making is a huge influence. Just speaking and thinking about the New York experience, at a point when we were pushing for the tool to have kind of higher release points, there was a lot of pushback from folks who are going to be using the tool every day in and day out, judges who thought to themselves, I might not be comfortable releasing this many people, given my own kind of experiences, my own thoughts about the ways in which the people who appear before me may behave or end up, and therefore we're going to reject that. We're going to reject those kind of cut points. Ultimately, legislation had to be passed, which of course has now been rolled back in New York, that drove the release rates higher, or sought to drive the release rates higher. But I think the challenges are numerous. One thing I do think we can probably do is respond a little bit differently to the data that we get. So instead of kind of making these decisions about who should we lock up or who should we detain, what are the types of supports or resources that an individual might need in order to come back to court with regularity? How do we ensure that they're able to steer clear of the criminal legal system or involvement with the criminal legal system again? How do we invest in those types of resources? And maybe there's a way to take these tools and kind of aim them at the system or the system actors to determine where these biases, where these inequities are surfacing, and address those rather than kind of aiming them at the people who are being driven through or dragged through the system, and being basically kind of targeted and sorted based on their own identity and their race.
And yeah, I would just add, and I'll keep this short to permit more questions. A good deal of my research prior to publishing this most recent piece was me trying to understand what was I missing, right, in terms of the literature, because much of the inquiries have been very similar to your question, Ben, which is, isn't there anything that can be done? Aren't there any interventions that could be made to actually make these racially equitable? And I feel like scholars like Megan, as well as an assortment of others, have really been engaged in that particular assessment. But Sandra Mason published this piece, Bias In, Bias Out, in the Yale Law Journal a year or two ago, and ultimately confirmed that because the nature of the data that these instruments are trained on is biased, yes, they are going to inevitably engage in biased predictions. But the recommendations that have been made have been either for us to change, responses to risk in the same vein that Vincent has named, or ultimately, to reconceptualize these instruments. But for me, what has been very evident is that we have seen experimentation in this regard, and what we're witnessing is that these interventions are more often than not neutralized, or they are not accomplished. I think of California in particular, which the original bill in that state included pretrial risk assessment instruments, was supported by grassroots groups, and the pretrial risk assessment instrument was intended to determine the needs of those who would be released. These instruments were intended to facilitate release, and yet that bill underwent dramatic change within a year or two, to where now the score generated by a risk assessment instrument is going to dictate wholly release and detention decisions. I think of Megan's piece with regards to your investigation into Kentucky, labeling these as evidence-based, despite the fact that there had not, in fact, been any inquiry or empirical studies confirming that these detention rates were accomplished. And when we think that these are going to invite very different responses, I just think that there are a myriad of incidents. I think many people on this call might be familiar with the ProPublica study, which kind of broke all of this open in 2016, looking at a pretrial risk assessment in Florida. And to those who would say that, well, this could potentially invite different responses, to risk. Well, Florida and Broward County, where this risk assessment was being used, they had been using that risk assessment for 8 years, prior to ProPublica engaging in its investigation. So I feel as if this ultimately contradicts what is a legitimate hope. And, I think Vincent has recognized, particularly in critical race theory, this recognition that yes, racism is deeply entrenched here. It's unlikely that we will ever move beyond it. But I think that there are, such real resistance efforts that are being engaged in. And what I am witnessing in terms of the landscape is that these instruments, despite a tremendous amount of potential promise, when we assess them in relationship to the institutions that they are being made a part of, the structures that they are being made a part of, then this promise is more often than not being accomplished, and more often than not is merely reinstating the racial status quo.
Right. Thanks. I want to first invite everyone to use the Q&A function in the bottom. I'm going to continue to ask some questions, but I would love to make sure that if you guys have any questions as attendees for the panelists, I get those asked. So yeah, there's a Q&A function down there. But sort of working off of what we just said, and thanks for that, Sean. Vincent, I know you're a former public defender, and Sean, I think you did some criminal defense work. How do you suggest practicing that defense counsel interact with these risk assessment tools, like when they're actually dealing with them, with their clients? On a day-to-day basis, obviously, criminal defense, especially public defenders, have very little time per client to meaningfully engage with every element of it. And so it's a really kind of a difficult question for you to answer with a lot of precision, because state laws are different and state risk assessments are different, even sometimes county to county. But there have been legal challenges based on due process. There have been legal challenges based on equal protection. And I was wondering if either of you have some words to any of the defense attorneys that would be watching this on how they can sort of interact with risk assessments used in the jurisdiction they're practicing.
Sure. So, I think the challenges kind of based on due process and equal protection are all valuable and worthwhile and worth making. A lot of those due process challenges are based on kind of a lack of procedural due process and understanding the data and having a transparency around the way in which the tool was made, who made it, what the data points were that were used to kind of help to construct it, and things of that nature. What I can say kind of from a practitioner's perspective as a public defender, and kind of the way in which I interacted with these tools before kind of having a full understanding of the range of problems they presented, was that the basic, I think, job of a public defender and a criminal defense attorney is like fundamentally at odds with a lot of the ways in which these tools operate, because your job is really to demonstrate how your client is different from or stands out from the crowd, so to speak, is not in line with the kind of judgments or prejudgments that anyone who's sitting in judgment of them may bring to bear when making a decision about their fate. And so what I often did in the course of kind of challenging ways in which these tools operate was demonstrate kind of how the calculus that the tools were providing was flawed in some way, how it didn't account for, if it looked at kind of someone's resident status, and I knew that factor was a factor that only looked back a year or 2 years, or was a factor that was asked by a pretrial services officer who may not have had a relationship had the kind of hallmarks of trust, where an individual would feel free to give that information to someone. I kind of talked about kind of how the tool itself was flawed in its methodology in terms of providing a forecast or an accurate forecast about my client's life, and really try to demonstrate how my client was different from what the tool is saying about them or telling you about them. Also kind of to try and capture factors that are not captured by the tool itself. So if you have a tool that's only looking at arrest history, for example, and I know that the police precinct within which that patrols the community that my client lives in is a precinct that's notorious for racial profiling, that's notorious for brutality, that's notorious for all the types of harms that we think that we know that police visit upon communities. I would flag and raise that point because from the standpoint of a tool, it's just looking at arrest history and not looking at kind of the number of arrests where police officers have been accused of misconduct or misbehavior. And so I think a lot of the day-to-day nuts and bolts challenges that defense attorneys have with respect to these tools really lie in kind of challenging the ways in which these tools are trying to measure and compare your client to a cohort of individuals who they do not look, act, or have any kind of share any characteristics with beyond kind of where they come from. and really trying to challenge the way in which these tools can come to some calculus about your clients or forecast about your client's life, which is undermined by the kind of individualized representation you're supposed to provide. So I think that was, for me, the bread and butter. And of course, the flip side of that was when the tools made predictions that I thought were helpful to my clients, as all lawyers are going to do. I said, well, look what the risk assessment
right.
should be released.
Yeah.
So I think there is like that challenge there. And of course, you're appearing in front of a judge, so you have to be sure that you are preserving your credibility in front of that judge.
Right.
But I think a lot of it is trying to demonstrate how the tool does not capture the whole person that your client is. Because in many ways, these tools kind of encourage the type of profiling that we all find abhorrent when we think about the criminal legal system and the way it operates.
If Sean or Megan, you have more to add?
Yeah, I mean, I think I would add, I think Vincent has provided a very accurate assessment. I really think that defense attorneys find themselves in a very difficult position, particularly when we think about the responsibility and commitment to provide zealous advocacy to your client. And I thought of this in terms of wanting to point to a pretrial risk assessment saying someone is low risk when your client is facing detention or a high bail amount. And so obviously wanting to lean into any type of risk assessment or report in those circumstances, whereas wanting to, express opposition otherwise. And, I have spoken to, some national defense organizations on this very same question around, well, what exactly can and should defense attorneys be doing in the courtroom when confronted by these instruments? And unfortunately, right, there is no easy solution. I think that, some of what Vincent's already stated is what I would recommend defense attorneys pursue, which is to at least minimally review the literature that exists currently around pretrial risk assessment, so that you are sufficiently informed about what it is that they do and what they do not do, right? And I think one especially important point is that these are metric most routinely, despite labeling people according to risk classification, it's in fact predicting the likelihood of arrest, right? And there is a conversation to be had. I just don't know, the capacity, the ability of attorneys to really be having this conversation in the courtroom. But, ultimately a judge's responsibility when they are vested with the authority to assess risk to public safety, that's not necessarily equivalent to rearrest rates. And arrest rates more often than not represent, disparities in policing, and if anything, reflect policing practices and policing priorities of respective departments. So I think that I would just recommend that folks, one, deepen their knowledge around what exactly the instrument is predicting, because I think it could be helpful to inform judges of this. And then two, I think it's helpful to draw on the literature, because nearly all of the literature confirms that, right, these instruments are, by the nature of their design, more likely to erroneously classify Black people as high risk and erroneously classify white people as low risk. And so I think that, right, naming that in the courtroom, adding that to the record can be significant and hopefully encourage a judge to not give as much credence to a risk assessment score when they're considering something like detention or post-conviction sentencing.
Right. That definitely makes sense. Thanks to both of you for the answers. I want to hit on validation studies quickly. And if Megan, you can explain a little bit about what validation studies are supposed to be generally and how they're not sort of all created equal. Some of them are not independently done or regularly done. Some don't actually take into account some of the bias that they may have been using. And just for a little bit of background, validation studies are just studies that are supposed to be done to evaluate a given tool and see if that has actually been working as intended given the data. So if Megan, you could talk a little bit to that and what you think goes into an ideal one, if there is one.
So validation studies are studies that are designed to prove really just that the tool is predictive, that it has some degree of accuracy. And there's a variety of different ways to do them. There's no really strongly established norms about how predictive a tool needs to be in order for it to be validated. But to be honest, I will say that I think there's too much attention paid on these. And the reason there's too much attention paid on these is because people think too much of what these tools are able to accomplish. Like they're really just more like sharp sticks. If you can, there's been some studies shown that you can do a horse race between a very fancy algorithm that has like, dozens of inputs and kind of like state-of-the-art machine learning statistical analyses. You put that up against a very simple tool with just 2 inputs, like say you're trying to predict failure to appear, you have age, once again, it's always age, and prior failures to appear, integer weights, nothing really fancy in how these 2 inputs are kind of like mixed up together. Mm-hmm. And you don't get that much gain from the big fancy tool. Right. And so with that in mind, like the issues about whether the tool, it was developed in one jurisdiction and is adopted in the other, is that okay? Are the 2 jurisdictions comparable enough? Like for me, I just don't get like too worked up over these types of questions. If you think of these tools as simple, I'm not saying there's not like more or less accurate ones, but like they're not that accurate. Like even the best ones, it's just hard to predict among a group of people that have been arrested. It's hard to distinguish between them and say this one is going to get arrested again in the future. Right. Or is not. So, and it also, kind of the validation studies ignore the question that's relevant to their use is how do judges use them? It's not just, there's never a tool that's like off there, really 100% deciding this person's detained, this person's released. It's like given to a human being who then looks at the tool and then it filters through the black box of their brain and then they make decisions. And so that's really the question that you want. Like, does adopting these tools lead to the kind of improvement that people that their advocates have promised? Like, does it result in, being able to, dramatically lower incarceration rates without seeing an uptick in crime or failures to appear, or vice versa, lowering crime rates without increasing the numbers of people locked up? And that, I've done 2 studies on this, and so far the answer is just not. Like the good things that people had hoped would come from them don't materialize. Right.
Sean or Vincent, if you want to add anything on validation studies, you definitely can. But if not, I can go on to the next question.
It's just good to get some validation from Megan on my assessment of validation studies. I think it is concerning. I think it's a point of reference for those who are in support of the instruments. I think they routinely make reference to, well, this has been validated, right? So again, kind of these series of justifications that get issued for why, this instrument in a particular jurisdiction or locality is exceptional or is different from, the other discriminatory.
The bad ones.
So I think that, it did not strike me that validation studies necessarily, right? I just was kind of moving through for myself, right, when I was building my knowledge around these instruments, and there's a good deal of technocratic language that's used around them. So really deepening my knowledge in this regard. And so, made this inquiry into, well, is the validation study the ground for why we should conceive these as racially fair or racially just? And ultimately, finding that, yes, it can be concerning, particularly, I think, in the context of, like the Arnold Foundation's tool, which is derived from, pretrial records from across the country, but is being utilized in, select jurisdictions where there might be a number of differences in terms of why, individuals are subject to release and subject to detention. So, it seems as if validation studies can occasionally be helpful in terms of at least catering an instrument to a particular jurisdiction, but the issues still remain. And, to Megan's point, I'm always very thoughtful around, well, are they even doing a very good job of what they are alleged to do? And rearrest rates for violent crime once someone has been released pre-trial are about 1% to 2%. So we're talking about, a very small margin of people who are subject to, who will be eligible should be eligible for detention for alleged dangerousness when we're talking about a very small pool, very minuscule pool of people who would even be committing new violent crimes upon their release.
Right. Yeah, Megan, if you want to respond.
I wanted to add, the one thing that I do think local validation studies are useful, and thanks to Sean for like making this pop to my mind, is if you do a validation study, you can then say to a judge, actually high risk of violent recidivism in this jurisdiction literally means like 2%, chance. It's not, I think that's a very common misunderstanding with these risk tools, even by judges that are experienced with them. They see a high risk level and they think it means a much higher risk than actually exists. And the validation study is a way of kind of demonstrating that for a particular judge in a particular jurisdiction.
We have two more questions and about 6 or 7 minutes left, so that should work. But I wanted to touch on some of legislation that have been passed in different states. So in Idaho, there was a law passed last year that sort of tried to get around the Loomis transparency problem, where a defendant has the right to be able to access some of the factors and the weight of those factors that are used against them as evidence. In Mississippi, there's a specific thing that required independent localized validation studies, that even if validation studies are not a good fix, it's some of the better brands of them. I was wondering if there are specific legislative fixes that if you were a state legislature would like to see passed, given the landscape in which risk assessments are being used currently. So anybody who has an answer for that would be great to start.
Yeah, happy to go. So the my forthcoming piece, Bail Reform and the False Racial Promise of Algorithmic Risk Assessment, specifically does look at PRAIs and bail reform through this lens of legislative change, in particular, juxtaposing New York and California. And I think that New York, I really holds up as a good example, not the best example. I don't think that we've necessarily seen, an excellent example of legislation that did finally facilitate, dramatic reductions. But I think that New York, I appreciate for creating a pathway that is not dependent on pretrial risk assessment. I think that, the conversation we're hearing most often is that these instruments are going to be integral to bail reform, and ultimately what happened in New York contradicts that claim. And I think that that's really significant, very important. New York is an outlier in the rest of the country in that way, as well as only ever having authorized judges to make predictions on the basis of future court appearance, so not on the future of alleged dangerousness. And so I think that the problem ultimately lies in judicial discretion and how we have dramatically expanded that discretion, particularly beginning in the 1970s. We did not allow, prior to 1970, judges to assess outright risk to public safety as part of bail determinations. And this was part of a series of carceral policies that increased, whether inadvertently or intentionally, the number of Black people in particular that were brought under the control of the carceral system. So I think that New York really represents a good example of let's restrict judicial discretion. We don't have to rely on pretrial risk assessment. Let's not permit judges to detain people at all when they are charged with misdemeanors and nonviolent felonies. Let's reserve judicial discretion for those crimes that by way of charge, represent perhaps someone who has a risk to public safety, but let's also ensure that we have some really robust evidentiary protections available to those folks as well, which includes having separate proceedings where we are talking about someone being subject to detention prior to their trial. So I think New York is a really good example. California's decarceral bill, how it originally started, I think was pretty good, but they might be getting a second bite at the apple because there's a referendum that will be voted on this fall in California to repeal their new legislation, which is relying on pretrial risk assessment, but that referendum is being driven and funded by the bail bond industry. So it's created some very strange bedfellows where you have coalitions that would potentially favor the repeal of this law, but on very different grounds in the bail bond industry.
Right.
Yeah, I mean, I think, I completely agree with Sean. I think in terms of when I think about legislative fixes, I don't think necessarily of fixes that that are aimed at the risk assessment instruments or algorithmic tools. I think of fixes that are aimed at making it that much more difficult for judges and prosecutors to hold people in custody in pretrial detention and set bail on them. And so, in making those standards that much more rigorous, requiring discovery, requiring an evidentiary hearing, and widening the net of people who are going to be released without any condition placed on their liberty while their cases are pending. And so I think when we think about those pieces, those are really kind of paradigmatic shifts to the way in which the system operates, not necessarily risk assessments. Because I think the reality is that if we ended the use of risk assessments tomorrow, the criminal legal system it's not as though the system is gonna change much at all.
Yeah.
We continue to operate in the same terrible way that it operates today. And so tinkering around the edges of the tools, I think while attractive is not really the solution that we're seeking or looking for.
Right, totally. And I know it's right up on 1 o'clock, but I know we got started a few minutes late. So the last question, and I know we've hit on this topic a lot and sort of how this intersects with the broader culture of the criminal justice system. But how does risk assessment tools and perhaps public education surrounding the fact that they exist and how they're used kind of work within the broader like movement, Black Lives Matter movement, and just like criminal justice reform movement, and efforts to address the over-incarceration and criminalization of many minorities, but especially Black. So if there's any, obviously it interacts with police activity, inextricably, but if there are specific things where these interact with that greater movement, I'd love to hear about that from anyone.
So, I think I've been witnessing, much like everyone else, the sheer scale of the movement we're witnessing across the country, right, where we're talking about actions and demonstrations persisting for days now, right? We're at our 30-something day mark of straight demonstrations, despite perhaps a lack of coverage. And we're witnessing, right, it on a scale that we have not seen since the civil rights movement. And so I think it's easy to trace this movement to the death of yet another unarmed Black person, but the movement is ultimately representative of a greater reckoning, right? I think that this movement represents not just how our society has conceived public safety, how our courts have contributed to a definition of public safety that authorizes violence and authorizes death as a response to an assortment of social issues. But I think that this critique, this reckoning, is also being laid at the feet of legal practitioners and the legal academy, and how we have conceived public safety and how we have contributed to these norms surrounding the safety of select people and select groups. So I think that in many ways, we have to be very deeply mindful of this, and I think change our approaches to our scholarship and to the nature of our inquiries, and particularly listening more to those who are directly impacted by these policies. I think that Kimberly Crenshaw's intersectionality theory, despite being thrown out maybe in inaccurate ways, really does speak to the need to acknowledge that those who lie at the intersections of multiple marginalized identities are harmed in distinct ways. And unless we recognize that one's socioeconomic status, race, gender identity collectively come together to dictate their experiences of the law, we're going to continue to pursue strategies and solutions that recreate these really violent reactions to folks. So those are things I think we need to be mindful of in relationship to the broader criminal legal system, but also in relationship to the move to pretrial risk assessment.
Right. Vincent and Megan, you want to add anything to that?
For some reason, these risk assessments have captured people's imagination in a way that not all of criminal justice does. It's become something that has been a door into a lot of really important questions and a lot of really important insights. at first when I started studying this, or when it started becoming like things people talked about, I didn't really get it. Like, you know, Vincent was saying, you know, getting rid of risk assessments is not going to like all of a sudden make, you know, the criminal justice system much better. And in the same way, adopting them in my mind does not automatically make it much worse. But regardless, you know, it like captures our mind. Like, it's got that creepy sci-fi Minority Report thing. It encapsulates a lot of really important issues and delivers them to people in a way that they really hear, in a way that, you know, they don't always hear it. And that's the thing that, you know, makes me, that's the connection that I see with the Black Lives Matter movement. Like, the type of change that we need, it's not like figuring out the exact legislative reform, the exact policy, the like tweak that's going to fix it all. It's really changing people's hearts and minds and how they see, you know, how they see the system, how they see issues around race, how they understand racism, like on a deep guttural level. And I think risk assessment, just the conversation about risk assessment, has actually been helpful in many ways in terms of helping to generate that shift, at least a little bit.
Right.
Yeah, I mean, I would totally agree with that. I think, you know, it's often the case that I think these tools give a false veneer of like scientific neutrality to, you know, kind of comfort to the workings of a system that we already know, or many of us know is already damaging and it's been broken on purpose for generations. And I think the conversation around these tools and kind of the critical analysis of these tools has forced us all to kind of reckon with the racialized fabric that's kind of woven into the DNA of our country. And I think what I noticed just in my own, you know, travels into this world is that the folks who were designing, developing, thinking about using these tools were completely divorced from that historical racial context and that racial justice lens.
Yeah.
And I think what we're seeing right now with the, you know, the rebellions in the streets and the renewed and kind of continued work by Black Lives Matter and other folks who are allied with Black Lives Matter is that there is this kind of growing consciousness about the pervasive ways in which race has infected our country from its birth. And I think you can't change these systems without changing the culture within which they are operating. And so I think part of the relationship is about changing the culture. And I think, as Megan said, as Sean said, these conversations help to shift that culture, help to shift that paradigm in some ways. And ultimately, I think what you hope is that to the extent you're going to build tools or do these things within this framework, you're doing so with that critical understanding about the way in which the world actually operates and is experienced by people who've been marginalized from the time we're brought here in ships to be enslaved. And so you know, that's the connection I see between the way these tools are kind of rolling out and the conversations around them and the larger movements that we're seeing in the streets. That we're all questioning the status quo, and we see these tools as part of ways to both uphold that status quo or potentially ways to tear that status quo down and start anew, because we know the status quo is not serving anyone in the way that we want it to.
Great. Yeah, thank you all, especially to Sean Hill, Vincent Sutherland, and Megan Stevenson, our panelists today. Sorry for going a little bit over the 1 o'clock timeline, but we really appreciate everything you said, especially we wanted to get those last insights in. So a recording of this is going to be available online, and EPIC also is going to have a report out in the next few weeks about these risk assessments, sort of compiling some of the research that has been done, as well as some of the legislative fixes, and hopefully that can act as a resource in concert with this, and hopefully the criminal justice movement can move past these and towards a more equitable system. So thank you all, especially to our panelists, for joining us, and I hope you have a great day.
All right.